Yesterday we had a great session of the beginning of where we are trying to deal with the various dimensions of the new law, particularly the Bharatiya Sakshya Adhiniyam. We did have certain basic, overview of what the Bharatiya Sakshya Adhiniyam is, and today we'll go to part two. Part two deals with relevancy of facts. Basically, the relevancy, of course, we had this even in the old code also, that is the Indian Evidence Act. Now, part two gets divided into, though it is headed as relevancy of facts, it gets divided into different subsectors, which I may say section 3 to 14, they deal with closely connected facts under the relevancy of facts. Section 15 to section 25 deals with admissions, which is one of the very important part of the Indian Evidence Act and the Bharatiya Sakshya Adhiniyam. And later on, section 26 and 27 deals with statements by persons who cannot be called as witnesses. Then 28 to 32 deals with statements made under special circumstances. 33 deal with how much of a statement is to be proved. 34 to 38 deals with judgments of courts when they are relevant. Then 39 to 45 deals very importantly with the opinions of third persons when relevant. Of course, it encompasses in it the law of expert evidence also. Then 46 to 50 deals with character when relevant. Now, as I said, the part 2 is titled as relevancy of facts. Now, what is relevancy is something that we have to deal with. Now, in simple words, I may say what is relevancy means what is relevant and it excludes what is irrelevant. Now, as lawyers, we have to keep in mind, of course, all of us must have studied a great depth of civil procedure code. Yesterday, I was saying that the Indian Evidence Act and the Bharatiya Sakshya Adhiniyam, now it applies to not just the criminal cases, though earlier we had the Indian Evidence Act under the criminal major act segment. Yesterday, I said that Indian Evidence Act, the law of evidence, is one and the same for all the proceedings or all areas of laws. Now, relevancy of facts deals with what is relevant. Now, as I mentioned to you, we all must have read Civil Procedure Code where there is one order and one rule which says what has to be pleaded. What should be pleaded is the facts. And we are not supposed to say in the plaint what is the evidence. Now, why such a fundamental principle is culled out and kept? There's an interesting background to it. Now, before the court, when we go, when a litigant is before the court, and on behalf of the litigant, when a lawyer keeps his case, lays his case before a court of law seeking redressal of justice, there is a disputed situation. A disputed situation means there is some dispute on the basis of certain facts. Now, what has to be kept before the court is the facts which are relevant to that particular dispute and the facts that are in issue. Of course, under the relevancy of facts, there are two major things. That is, number one, the facts and facts that are in issue. So, therefore, the Civil Procedure Code clearly says what is a fact, what is a fact in issue. Now, if we look at section 3 of Bharatiya Sakshya, section 3 deals with evidence may be given in any suit or proceedings of existence or non-existence of every fact in issue and such other facts as are hereinafter declared to be relevant and no others. Please notice that it clearly excludes anything else to be stated other than the facts and facts that are in issue. There cannot be anything else. Now, we must have seen quite often we end up saying so many things in the client, in our written submissions, in our clients, which are not in fact relevant. Of course, sometimes we see a client which runs only into a couple of pages. Sometimes we have also seen the clients which runs into a rhetoric of hundreds of pages. Why the statement of facts has to be precise and it has to be limited. The law clearly demarcates what has to be told and what should not be told. Because if you go on saying something which is irrelevant, you are not just spoiling your case, spoiling the brief which you are laying before the Honorable Court, you are also disturbing the court by putting so many things which are totally irrelevant. Therefore, Section 3 clearly excludes that nothing which is not relevant should be stated. Of course, this is a rule under the Civil Procedure Code also. Once again, I read it at the cost of repetition. Evidence may be given in any suit or proceedings of existence or non-existence of every fact in issue and such other facts as are hereafter declared to be relevant and no others. So, fact in issue is something which is called a disputed situation where you are asking the Honorable Court to come into and redress the dispute, and facts which are relevant for that, for legal practitioner to take the courts through what all relevant to troubleshoot the situation which are the facts in issue, you will have to place the facts in issue. Now, under Section 3, there is something very important. You must have seen only a few laws have something called as illustrations. So, if all of us understand and read the illustrations provided under every section, in fact, we are understanding the particular law to a very great extent by going through the illustrations. So, why the illustrations are kept means law could be in its simple language at times, not conveying sufficiently, and it could be confusing too at times. Therefore, the lawmakers themselves have, in fact, thought of keeping the illustrations so that the understanding of the law becomes simple and we simplify the work before the court. In spite of reading all these things, in spite of reading the sections as it reads, in spite of reading the explanations attached to it, and in spite of reading the illustrations which are given under the very provisions of law, if we still don't understand and keep a very confused picture before the court, then we are not only doing injustice to our clients, but we are also doing a great amount of violence to the honorable courts. Therefore, we have to be very careful while putting our case before the court, and it should align to what is provided under law. Then the delivery and the speed of delivery of justice also will become far more easier, far more faster than what we are experiencing now. We have so much of pendency before the courts, and as lawyers, I think we may have to introspect ourselves and say that we are the major contributors to the delay in delivery of justice. Therefore, hereafter, at least let us all make a prompt attempt at what we should say before the court, what we should not say before the court, what is only relevant, what is irrelevant. So we will sieve out all which is not relevant, which is irrelevant, and we'll keep only the relevant things by going through the strict rules of law of evidence. Now, as I said, under Section 3, there is something called as explanation. Not all the sections of the code or not all the sections of the law always comes with an explanation. So why is this explanation given? The explanations are provided in order to give more clarity to the law, because when the law is conceived at the legislature, there may be so many underlying circumstances, there may be so many, there may be a different atmosphere or environment under which the laws must have been made. So when they are printed by way of a coded provision, it should not give any other meaning, because we all can perceive different things. No two human beings will perceive the same thing. Everyone, when looks at a single picture, they have different perceptions. I look at something, I have a different perception in my mind. Somebody else looks at something, they have a different perception in my mind, in their mind. Therefore, the idea of providing explanations is that to, in fact, limit the perceptions getting scattered, limit different perceptions and different understandings. Therefore, the lawmakers, whenever they feel that there could be something confusing, there could be something which is capable of being interpreted in different ways, they always add explanation. Now, for section 3, there is an explanation. This section shall not enable any person to give evidence of a fact which he is disentitled to prove any by any provision of law for the time being in force relating to civil procedure. Of course, the reading of law in the beginning will sound a little cryptic, but when we read it twice or thrice, in fact, we get a clear picture, more clarified version of what we are reading. Of course, so many judgments, particularly on the criminal law side, we have been seeing all along. We have been having a great judicial system for times immemorial, but every day the law changes, every day the understanding of the law changes, every day the interpretation offered may change. Why does it happen? Of course, this happens because there is always something more which is possible on the side of interpretation. Therefore, the explanation when accompanied, therefore, whenever there is a particular provision of law is accompanied by an explanation, to a great extent, it limits the law being interpreted or law being stretched to a purpose for which it is not meant by the legislature. Now, under this section also, there is an explanation which limits that what all can be kept. Something which you are prohibited to keep before the court under law, which you can never keep, even if sounds as relevant. Now, of course, many of you must have by now bought these books. If all of you, many of you, if you can have the book also side by side, it may give us a better picture when I am reading. Under section 3 itself, there are illustrations that are given. The illustrations also conveys us what exactly are the circumstances which are meant under the main provision of law. Now, jumping out to section 4, relevancy of facts forming a part of same transaction. Now, what all that could be relevant in a particular matter. Now, let us suppose, let us imagine a property dispute. Now, there is a property dispute. A owns a property and B comes and disturbs his possession, disturbs his right. Now, when there is a disputed situation, there is an adverse claim laid against the property right of a person. You go before the court and you start telling that how you are the owner, how you are the only person who is entitled for the property, etc., etc. Now, if you simply say, though I am the owner of the property, somebody else is coming and simply disturbing, it does not convey the complete matter before the court. The court should always say, if somebody who is not entitled, who has no rights, who is a stranger to A's right, why is he coming and disturbing? He must also have something to say from his side. This is what this is how the court presumes it. Therefore, at the time of saying something that determines, that says what is your right, you would also say something which in fact forms the part of same transaction. Now, B must have been an earlier owner, or B must have also bought a piece of property from the same vendor which you have bought. So you will have to keep all those facts also along with your facts in issue, so that you are giving a greater picture to the court. And even section 4, under it has a lot of illustrations. I would request all my friends to read the illustrations. And coming to the old act and the new law, there is hardly any difference. And in fact, I may say that there is as such no difference, except that it is rearranged and kept under different provision of law. And section 5 reads with facts which are occasion, cause, or effect of facts in issue are relevant facts. Now, what is the effect of a particular fact? Now, if we have a disputed situation, let us say there is a criminal case. Let us say there is a criminal conspiracy to rob a bank. Now, a person who is sitting elsewhere in some other place may come out with this idea of robbing a bank and instruct who is sitting in totally a different place to do it. Now, a person who is though not present in the same scene, where he is sitting, what his intentions, all these things will become relevant. Now, to a great extent, the relevancy of facts, the chapter, the part of the Indian Evidence Act, or the part of the Bharatiya Sakshya Adhiniyam which deals with the relevancy of facts, it is not just a guiding factor to what the lawyers have to do before the court, it is also something to do to guide the investigators. Now, we must have seen every investigation begins the moment, of course, under the criminal law I am citing. The moment you tender a complaint of a cognizable offense, the investigation starts. The investigation is what? The investigation is the process of collection of evidence. Now, what all the investigation officer has to look at to collect evidence? Should he look at only your complaint? Should he look at only the complaint and the information and try to investigate, or should he also look at so many factors surrounding it and the after effects of it? Let us imagine a situation, a person who was till yesterday working as a daily wager or a casual labor, suddenly tomorrow he starts driving a very expensive car. So when you are looking at that, the after effect, it suggests that something has not been clean behind this, because till yesterday he was in a particular status. It is impossible under given circumstances for him to become overnight rags to riches. Therefore, there must be something. So that particular fact, the after effects, that why he has been able to drive an expensive car, means there must be some proceeds of crime. So all this becomes relevant. Therefore, the Indian Evidence Act, under the relevancy of facts particularly, does not guide only the lawyers and the courts. It guides vastly the investigation process, the investigators, where the investigators can make use of what all is relevant, and they can also stop what is not relevant. So many times they end up even investigating into areas that are prohibited under the law of evidence. For example, under the old Evidence Act, we had something called as the past conduct of the accused is not relevant. Section 54 of the old act said. Now, the investigation officers in their course of investigation would bundle up a lot of material to show the past conduct. Sometimes the past conduct is relevant to perceive that a person who has got this kind of a checkered history, this kind of a soiled history, can never be having clean intentions, and his intentions and motive to commit a crime is well laid by placing those particular past history. But when they are doing that, they forget the mainstream of investigation. Therefore, the law of evidence, and particularly the Bharatiya Sakshya, limits what is relevant and what is not relevant. Now, then going to section 6, motive, preparation, and previous or subsequent conduct. Some parts of relevancy of facts, it applies to all kinds of cases, may it be civil, may it be criminal, or may it be any other areas of law, but some part of the Evidence Act, the Bharatiya Sakshya, it in fact it applies with greater force, with greater particularized circumstances to criminal matters, because for example, section 6, motive, preparation, and previous or subsequent conduct, these are all we see more in criminal jurisprudence. And of course, even to commit a civil wrong, there could be a motive, there could be preparation, but these some sections of Bharatiya Sakshya, it applies more to criminal matters. And what all is relevant when it comes to motive, preparation, and previous or subsequent conduct could be, of course, this I may have to read the section because this is quite important and we often use this in the courts. Now, when I am reading section 6, subsection 1 of section 6 reads, any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. Then subsection 2 reads, the conduct of a party or the conduct of a party or any agent to any party or to any suit proceedings in reference to such suit or proceedings or in reference to any fact in issue therein are relevant thereto. The conduct of any person or offense of an offense against whom is subject of any proceedings is relevant. So what is relevant is clearly called out, and once again section 6 has an explanation added to it. The word conduct in this section does not include the statements unless those statements accompany and explain acts other than the statements, but this explanation is not to affect the relevancy of statements under any other section of this adhiniyam. So we have to carefully read the explanation and try to understand. An explanation is an extended version, extended part of the basic section. Therefore, without the explanation, reading of the section will be it will become incomplete, it will fall incomplete, and there is explanation 2 also to section 6. That explanation reads to the effect that when the conduct of any person is relevant, any statement made to him or his presence and hearing which affects such conduct is relevant. So it deals basically with the conduct of a person. I see some message there where some of my friends who are on this session are also requesting for Kannada. I don't know if Mr. Gautam Chand, the academy permits. I can also say a few things in Kannada, but I hope I'm using a very simplified English and which should be understood by all. Therefore, we will think of switching over to the instruction, the medium instruction, little later, but we'll continue now. Section 6 also has illustrations, and we are not going section by section, and I am just taking you through what I feel is quite important for the day-to-day practice. Then section 7, facts necessary to explain or introduce fact in issue or relevant facts. Sometimes an introduction is necessary. See what happens. I can cite an example. If a person walks into a police station with a complaint or with some information of a cognizable offense, he has to first go and give certain introduction, because without introduction somebody may look at may seem a total stranger, may look an alien. Therefore, whenever the circumstance demands, an introductory fact is necessary, though that particular introductory facts may not be relevant in the next stage of the case, but those facts which are introductory to the main facts or main facts in issue are also relevant. Then section 8 reads with things said or done by conspirator in reference to a common design. Let us imagine a situation if the main offender is different and the conspirators are different. So whatever the conspirator does, that becomes relevant when to deal with the main offender. And of course, conspiracy means it sucks in everyone who is a part of the crime. Therefore, section 8 clearly details even whatever that is said and done by the conspirator in reference to a common design. Common design means more persons having a conspiracy to commit an offense with a common design. So more persons with meeting of minds will design a particular offense. What is an offense is basically a wrong which is prohibited under law. So a common design means a design conceived commonly by more people to commit an offense. So things said or done by the conspirator in reference to common design also becomes relevant. Then section 9, when facts not otherwise relevant become relevant. Sometimes at the time of initial level, many facts may not seem relevant. But in a later course, what was felt irrelevant becomes relevant. So there are examples given, illustrations given. Therefore, the illustrations have to be read carefully. With the reading of illustrations, we'll be able to better understand. The illustrations gives a clear insight that how something which was not relevant at particular point of time becomes relevant at a later point of time. Therefore, when we are keeping the facts before the court and the facts in issue before the court, all these things have to be kept before the court, and there is no much change to that. Then section 10 reads facts tending to enable courts to determine the amount are relevant in suits for damages. Of course, this particular section deals particularly with respect to suits for damages. Let us imagine a situation that damages can be different for different. It could be perceived differently under different circumstances. Um for example, if I claim damages for a wrong suffered by for a defamation suffered by me by an act of somebody, the damages which I am trying to quantify as against the loss of reputation may be different. At the same time, a person who is placed on a higher pedestal than me, for him, the quantification of the damages may be different. Similarly, the mental agony, the damages suffered by a person who is standing at a particular strata may be different. A person who is standing at a different strata may be different. This is because equality is amongst equals, equality is never a concept amongst unequals. Therefore, when quantifying the damages, the court will be faced with a situation of different circumstances and different stratas. Therefore, all those facts which are relevant to determine what is the damage in a particular circumstances, not in a generalized circumstance, in a particular circumstance becomes relevant. If a particular person placed at a particular situation suffers a damage under a particular set of facts, so whatever that is necessary to quantify the fair damages, all those facts becomes relevant. Suppose we must have seen in this family disputes, the damages claimed by a spouse of a particular stature, then when the courts are requested to decide upon the quantum of damages, the person who is standing at a particular stature will keep a particular extent, particular quantified uh, quantum of damages, that this is what which I have suffered. Then the courts, at the time of considering those particular quantums which are kept before kept before it, will look at the entire circumstances surrounding that, the stature, social status, the educational background, the employment background, and so many other things, and then quantify the damages on a fair scale. Therefore, whatever that is relevant to quantify, to arrive at a fair quantifications, all those things becomes relevant, though not the facts in issue. Then section 11 deals with facts relevant when the right or custom is in question. We have experienced this particular part many times. Suppose when we go before the court, we say I have a customary right. In Karnataka, we have some customs which give special rights to certain class of people. Of course, in Dakshina Kannada side, we have something called as Aliya Santana. In Kerala, we have something called as Marmakattayam, where there are customary rights based on the local folks way, local customary practices, local folkways. When a claim is laid before the court which hinges upon a particular custom, all those things which are necessary to prove that particular customs becomes relevant. The social atmosphere, the facts surrounding that particular vicinity, the particular geography, the particular demography, all these things will become relevant when facts when there is something which is being decided with respect to a right of custom. That's what section 11 deals with. And section 12 deals with facts showing existence of a state of mind or body or bodily feeling. This section 12 is very, very important, because state of mind is something which, unless put in action, cannot be read very easily. As all of us know, there are different stages, especially under criminal jurisprudence, there are different stages of crime. First, there is intention. Second, there is preparation. Third, there is attempt. Fourth stage is when the offense is committed. So, if one inside his mind has just an intention to commit a crime, that itself will not become punishable, because the intention is inside. Intention is not expressed by way of any acts. Therefore, an investigation when begins, it gets into history. Means an investigation is a reverse process. An investigation starts after the crime is committed. So the process of investigation, in the process of investigation, which starts after the offense is ended, will probe into the history of the offense. So the history of the offense, when it is probed, then all these aspects, existence of state of mind, or body or bodily feeling, all these things becomes very, very relevant, because unless and until there is mens rea, so many things following mens rea may not come into existence. Therefore, Section 12, our criminal law practitioners may have to read at greater depth for a little detailing. Let me just read how Section 12 reads. Of course, this was there under the Indian Evidence Act also. Now, Bharatiya Sakshya keeps it as it is. Facts showing the existence of a state of mind, such as intention, knowledge, good faith, negligence, rashness, ill will, or goodwill towards any particular persons, are showing the existence of any state of body or bodily feeling are relevant when the existence of any such state of mind or bodily feeling is in issue or relevant. Generally, in criminal law, uh, of course, in a civil litigation, the plaintiff places before the court all that what he has to say by way of a plaint. Within a short succession thereafter, the written statement comes before the court. So at the very initial stage itself, the honorable court will have both the versions. What is the version of the plaintiff and what is the version of the defendants? Then the issues are framed that what has to be troubleshot, what has to be answered to lay a judgment to a particular dispute. But under criminal law, it doesn't happen so. A criminal case begins with a complaint and the prosecution laying a charge sheet. Now, when the defense version comes in here, under the criminal law, most of us are aware that the investigation starts, laying of the charge sheet, after the laying of the charge sheet, then framing of charges, after framing of the charges, and of course, framing of the charges would be preceded by hearing before the charge, and after framing of the charges, and if it is felt that no, there is nobody who is entitled for a discharge, then it proceeds into prosecution evidence. Evidence will be led by the prosecution. Then thereafter, the prosecution witnesses will be cross-examined, and if there is any ambiguity, the witnesses will be subjected to re-examination. Once the prosecution evidence is complete, then comes the statement by the accused, which of course under the Nagrik Suraksha Samhita, it is kept under different provision. Of course, the old provision was 313, where the court will pick up the incriminating parts of the witnesses which are laid against the accused persons and will ask the accused, a particular witness has said something like this which inculpates you. Therefore, would you like to say something? Then after the 313 is read over, then the court will ask, do you have any defense evidence to place before the court? Because the burden of proof is initially on the prosecution, except for certain laws or for certain offences where the burden shifts. Otherwise, the general burden of proof is on the prosecution. So after that defense evidence, the next stage is arguments. Arguments, of course, it is a book stage. Thereafter, the court will proceed to the judgment making process. So when the defense actually comes in a criminal trial at last but one stage, unlike in a civil case where you have the plaintiff's version and the defense version almost side by side, of course, at almost within a very short gap of time. But in criminal jurisprudence, it doesn't happen like that. The defense, if any, comes only at the last stage. So what exactly is the defense in a criminal trial? Means defense is nothing but rebuttal of the prosecution case. So the prosecution will keep all the evidence before the court which which the prosecution feels as necessary to prove its case which is laid before the court, then the defense has to rebut that by way of cross examination or whatsoever, by way of in fact applying the law of evidence, saying that this part of the evidence cannot be looked into because it suffers some prohibition under law, may it be hearsay evidence and may it be something a confession or an admission which cannot be accepted, may it be a signed statement of the witness which is prohibited under law, so many things like that. So why I said this is, under law, under particularly criminal jurisprudence, the burden is large upon the prosecution. So therefore, section 12 details what all that has to be kept before the court: facts showing existence of a state of mind or body or bodily feeling, because unless all these material is before the court cannot presume something. Court has to go through the evidence, because what happens before the court is something like a mathematical combination. It is 2 plus 2, 4. Of course, our trial courts cannot apply discretion to a great level because it has to go strictly by evidence before it. If there is no evidence, then the court cannot simply presume something before beyond the evidence. Therefore, the prosecution has a greater duty to keep all that is relevant before the court, and if all that is relevant is not kept before the court, then the defense can always take advantage of it. Therefore, we'll have to see, when we are looking at the charge sheet, we'll have to see whether everything which is required, everything which is relevant is culled out and kept. If something which is relevant is not there, then you'll have to take advantage. So in civil case also, you will have to see whether the plaintiff has kept everything relevant. If the plaintiff fails to keep something which is relevant, then you will have to take advantage of that and deal with it. Then we shift over to section, of course, see section 12 has so many, has two explanations to it, but so many illustrations. The illustrations which is provided under section 2 gives a great insight that what all could be kept before the court, and the investigators may have to keep this in mind, and so also our defense lawyers. Then section 13 reads facts bearing on questions whether act was accidental or incidental. So whenever there is a disputed situation, whenever there is a fact in issue that one claim it is accidental and the other say no, it is not accidental, it is in fact intentional. So whatever that is relevant to show that it is not accidental but it is intentional, that has to be kept before the court. Of course, when we are talking about something accidental, there is one doctrine that comes into my mind, that is called as doctrine of res ipsa loquitur. Of course, some jurists of the West have called it res ipsa loquitur is not a great doctrine, but of course our courts, especially the courts that are dealing with this accident claims, MVC courts, have accepted this doctrine to a great extent, because when you see a car which has met with an accident, which is in fact wrecked by another vehicle on a wrong side, the moment you look at it itself, you can make out that there is somebody who has violated law, and he has that has resulted in an accident. So as you look at the wrecked car itself, that itself conveys you that there has been an accident and it is because of somebody's negligence. This is called as res ipsa loquitur. That means the scene, the thing which speaks for itself. So whenever you have this kind of a situation, most of it speaks for itself, and whatever that is relevant to in fact demolish the defense, that has to be kept before the court, then that becomes relevant. If somebody takes up a defense, no, it is not an accident, then you will have to rope in more things that are relevant to show that yes, this is an accident. Suppose if someone was driving a car in a drunken state, then what also becomes relevant is you will have to look at the person's conduct. Has he been fined before for drunken drive? Does he generally drink has he suffered any convictions for drunken drive? Has he got the history of violating traffic rules? Has he got history of driving late in the night, rashly and negligently? All these becomes relevant. Therefore, I was reading a particular section when facts otherwise not relevant becomes irrelevant. Depending upon the defense taken by the other side, so many things that were initially not relevant becomes that were initially not irrelevant becomes relevant at this at a later stage. The 13 deals with fact bearing in question, facts bearing on question whether act was accidental or not, intentional, all those things which are necessary to establish that it was not accidental, it was intentional, or it was not intentional, it was accidental, it becomes relevant. Then section 14 deals with existence of a course of business when relevant. Because there is a very beautiful illustration that is given. Let us suppose what is existence of course of business. The moment the financial year ends, we all will have to file the returns. This is general course of business. The moment we enter the courtrooms, the general course of business is that we can't be dressed shabbily, we'll have to be in our robes and we'll have to have a minimum, we have to maintain a minimum discipline, what is expected under rules. So this becomes a general course of business. So one cannot come and say something other than what is generally practiced. So section 14 deals with existence of a course of business when relevant. When someone disputes a particular situation, you can always say by quoting a relevant fact that it is generally like this, so somebody cannot have something else in their mind and try to disprove it. What is called as the doctrine of legitimate expectation is in fact based on this. Legitimately, you expect something has to happen in a particular style, in a particular method, and it has become a general course. Therefore, someone cannot have a different perception, a different argument that it should not have been in such and such style. I'll only read one illustration which is attached to section 14. The question is whether a particular letter was dispatched. The fact that it was ordinary course of business for all the letter to be put in a certain place to be carried to the post, and that particular letter was put in that place are relevant. The illustration itself is quite speaking enough to convey what exactly it means. Then section 15 onwards, it is admission. Admission deals with a greater depth. Do we have so much time to go on with admission? I think yes, we have. We have another 15 minutes. Admission plays a very important part of law of evidence. Now, before I go to speak about what is admission, let me just first read how the section reads. Section 15 defines admission. An admission is a statement, oral or documentary, or contained in electronic form. Please see, electronic form is the new addition because the earlier law was alien to electronic formats of admission. Now, one of the major reasons for Bharatiya Sakshya Adhiniyam is also to include everything that touches electronic progression, electronic administration. Therefore, electronic is added. An admission is a statement, oral or documentary, or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances hereinafter mentioned. So, in fact, section 15 should always be read in conjuncture with the sections which are thereafter. Now, let me therefore read section 16. Admission by party to proceedings or his agent. Statements made by a party to the proceedings or by an agent to any such party whom the court regards under the circumstances of the case as expressly or impliedly authorized by him to make them are admissions. Many of the times we have seen defenses being taken that no, it is an admission made by somebody else, therefore it is not binding. Let us imagine a situation, a person has given a power of attorney to another person to do certain things on his behalf. Now, once a power of attorney is given, and whatever the person who is holding the power of attorney on behalf of the farmer person, whatever he does, it becomes admissions by the first person who has given a power of attorney. A defense cannot be taken to mean that no, this person has done at his own level, therefore, whatever he has done, that cannot amount to admission. The law clearly defines it. And statements made by section 16, subsection 2 reads, statements made by parties to suit suing or sued in a representative character are not admissions unless they were made while the party making them held that character. Now we all know what is a representative suit. A representative suit is something like one files for the good of many in a representative character. A person who sues in a representative capacity always comes and says, I am suing for a cause which does not belong only to me, or which does not matter only to me, but it means to many. Therefore, I am suing in a representative capacity. Of course, there are different norms to go before the court to lay a representative suit. But law of evidence, section 16, subsection 2 clearly says parties to suit, suing or sued, because a representative judgment, a judgment delivered in a representative suits, it binds everyone. It is a judgment in rem. Therefore, anything done by a person who is acting in a representative capacity, if he makes an admission, does it bind in rem? Clearly, there could be such a situation of being defined in such a fashion. Therefore, subsection 2 clearly gives a clarity. Parties to suit, suing or sued in a representative character are not admission unless they were made while the party making them held that character. Then thereafter, Roman 2, subclause A, persons who have any proprietary or pecuniary interest in the subject matter of the proceedings and who make statement in their character of persons so interested. So many admissions made by different persons under different circumstances are brought under section 16. Why admissions play a very major role in the justice delivery system means we have a basic principle that admitted facts need not be proved. What we do before the court is trying to prove something which is disputed. What is admitted need not be proved. Therefore, the law pertaining to admissions culls out various circumstances that what is admission, what is not admission. So whatever that fits into the brackets of defined admission under particular circumstances, if we keep so much before the court, that is more than sufficient. You need not to labor much upon to prove, because admissions need not be proved. Then section 17 deals with admissions by persons whose position must be proved as against a party to suits. I'll just read the complete provision. Statements made by persons whose position or liability it is necessary to prove as against any party to the suit are admissions if such statements would be relevant as against such persons in relation to such position or liability in a suit brought or against him, and if they are made whilst the person making them occupy such position or is such subject to such liability. The section by itself is bit cryptic, but I just ease it by citing an example. Let us suppose a person was holding a power of attorney. The maker of the power of attorney, the executant of the power of attorney dies. Now, whatever that is said, admitted by a power of attorney by a power of attorney holder, when the power of attorney, the executant was alive, of course, that will have the binding effect. Once the executant dies, the admissions made by such a person after the executant has died, then they may not be considered as admission, because the admissions are not made on behalf of the person who is not alive. Therefore, illustration is very important. under section 17. A undertakes to collect rents for B. B sues A for not collecting the rent due from C to B. A denies that rent was due from C to B. A statement by C that he owed B rent is an admission and it is relevant fact against A. So what all the admissions that are made by third parties that would bind is clearly called out under the provision. This was earlier under section 19. Now it is shifted to section 17. Then 18 deals with admissions by persons expressly referred to by party to suit. Statements made by persons to whom a party to suit has expressly referred for information in reference to a matter in dispute are admissions. Of course, this is directly what the parties have admitted before in a suit. Of course, that binds them without any concession. The illustration is also very simple. A says to B, go and ask C. C knows all about it. C statement is admission. Quite interesting. Though the illustration is very small, please see the depth of it. A tells to B, go and ask C. C knows everything. Don't ask me. In whatever the temperament. Whatever C says becomes an admission because A is saying, go and ask C. C knows. So whatever C says in the context become an admission by A because A is virtually relegating his admission to the mouth of C. Very interesting provision, section 18. I think we should all use this in as many circumstances we may face in the courtrooms. Section 19 defines proof of admissions against the person making them and by or on their behalf. Section 19 requires a very detailed reading. I am going to stop today at section 19 because section 19, proof of admissions against persons making them and by or on their behalf. Section 19, in fact, deals with proof of admission. Till now, we were talking admitted things need not to be proved because they are admissions by themselves. We need not to labor upon proving that. But admissions also sometimes requires proof. That's what section 19 deals with. We will deal with that in tomorrow's session. Of course, in so far as the relevancy of facts, since we are already an admission, there is nothing much that we may have to deal with. Of course, after admissions, there are some portions of relevancy aspects which we may have to touch upon and go. Section statements made under special circumstances is something which we have to deal with at a greater depth. Section 19 we will deal with tomorrow, and today's session we will just have one rough glance at what we dealt today. Today we dealt with relevancy of facts that are closely connected facts. Section 4 to 14, relevancy of facts forming a part of same transaction. That means so many things may be interconnected and everything that forms a part of connected things, all that becomes relevant and we may have to keep it before the courts or we may have to practice it. Section 5, facts which are occasion, cause or effect of facts in issue are relevant. That means something may have an after effect. That after effect becomes relevant by looking at the after effect. We can have so many things presumed, so many things assumed, and so many things proved or disproved. Therefore, every after effect becomes relevant. Then motive, preparation, and previous and subsequent conduct is relevant. Facts necessary to explain or introduce a fact in issue are relevant facts. Once again, we'll stop it here. Fact in issue and relevant fact are two major things that we have to keep in mind. Fact in issue means a disputed fact which requires to be proved before the court, and that's what for which the redressal is sought before the court. And to in fact get justice in respect of fact issue. Fact issue.
Yes, sir. I want to go to Silicon Street. Silicon Street.
I would request our audience to not to disturb in between. Of course, fact in issue is something that has to be sorted out before the justice delivery system. Therefore, whatever that has to be kept before the court to ease the honorable court's job of redressing the fact in issue is a fact which is relevant. More relevant facts which we keep, the easier it will be for the courts to deal with the situation, and at the cost of repetition, I would say more relevant facts, not irrelevant facts. So let us be mindful, stick to the fundamental rule that we keep, that is relevant before the court and not something which is irrelevant, and we don't keep evidence in our pleadings. In evidence, we only say facts. Thank you for today's session. And I think we may have to take questions. Moderator.
Thank you, Mr. Shyamsundar sir, for discussing the nuances of the newly implemented law. Now the forum is open for question answer session. Kindly requesting all the participants to send across your questions in the chat box. I request Mr. Mallikarjun sir to pose the questions before the esteemed speaker. Thank you.
Very good evening, sir. We have a question saying that, sir, this fact in issue and relevant fact, does this fact in issue does appear in the criminal proceedings?
Certainly, because see, fact in issue, in fact, if I may read the first section, just allow me to just answer this. It does, of course, it does. If I may read section 3, at the cost of repetition, evidence may be given of facts in issue and relevant facts. And if I read the illustration under section 3, A is tried for murder of B by beating him with a club with the intention of causing death. At A's trial, the following facts are in issue. Number 1, A is beating B with the club. A is causing B's death by such beating. A's intention to cause B's death. Of course, fact issue is applicable, is something which is there both under criminal law and under civil law, and of course in every area of law. Fact in issue means a disputed fact. So it is not that in criminal law there is no fact in issue. Of course, in criminal law also there is fact in issue. The illustration itself clearly speaks of it.
Likewise, we have one more question, sir, from Mr. Santosh. That how about the motive and preparation plays a role in civil cases? Does this section 6 only restrict to civil cases, or does it have to come to criminal cases? Because we come across the very often.
I in fact said, if once again, please read. Of course, that's the reason I would request from tomorrow onwards all our participants to, as much as possible, to have the book with you. That is the Bharatiya Sakshya Adhiniyam. Section 6 reads motive, preparation and previous or subsequent conduct. If we look at illustration B under section 6, A sues B upon a bond for payment of money. B denies making of the bond. The fact that at the time when the bond was alleged to be made, B required money for a particular purpose is relevant. Of course, intention to commit a wrong. It could be either a civil wrong or it could be a criminal wrong. It could be a crime. Therefore, as I told you in yesterday's session, and at the cost of repetition, I am saying it once again to all our audiences today, that the law of evidence is a neutral law. It does not selectively apply only to criminal cases. It does not selectively apply only to criminal cases, only to civil disputes. It applies to all area of disputes. It applies to civil disputes and criminal disputes and all other disputes as well. Therefore, it's not that sections of Bharatiya Sakshya are to be read only for criminal cases, and it is not
Something went wrong.
necessary for civil cases. For only one particular area of law, there is a specific exclusion of application of Indian Evidence Act, that is the arbitration. But of course, even in the arbitration, the exact law is not made applicable, but the principles of Evidence Act are made applicable, because there are catena of judgments on that, where the honorable courts have held that though in strict sense the law, Indian Evidence Act or the Bharatiya Sakshya Adhiniyam does not apply as it is, but the principles of law of evidence are applied.
Chat box. Right now, I'm unable to see any questions, sir. Thank you, sir. Now I request Sankirtana to take over.
Thank you, sir.
Thank you.
We thank our esteemed speaker, Mr. Shyamsundar sir, for spending his precious time enlightening us about the new evidence law. We are very grateful to have you as our esteemed speaker for the lecture series, sir. Thank you so much. This academic initiative is a week-long continuous lecture series. Beginning yesterday, it will continue until Friday, that is the 12th of July 2024. I am requesting all of you to join us for the next 3 days as well to expand our knowledge about this vast topic. We certainly hope that this lecture series will help you better understand the nascent law. We hope to see you again tomorrow. Thank you for attending today's session. Thank you.
Thank you. Thank you so much, sir.
Thank you all. Thank you all.
Thank you.
We'll meet tomorrow again.
Sure, sir.
Thank you very much.
Thank you very much.
Thank you so much, sir.
Thank
you. Thank you very much. ಕಲಾಕಾರರು ಸುಮ್ಮನೆ ತೋರಿಸ್ತಿಲ್ಲ